Mr. Zhulkarnain Abdul Rahim.
Madam Deputy Speaker, if I may quote from the Court of Appeal judgment in the case of Dakshinamurthy earlier this year, quote, when a prisoner has been sentenced to the death penalty and is to be deprived of his life, he does not necessarily lose his other legal rights. Among other things, the exercise of discretion by the state in scheduling his execution is subject to legal limits, including the usual principles of judicial review and the fundamental liberties protected by the Constitution of the Republic of Singapore, end quote. Those were the words of Justice of Appeal Andrew Pang, a luminary legal giant who was honored by members of the judiciary, legal profession, and our greater community in his valedictory reference at the Supreme Court yesterday, which I attended. When I was just a young law student, I observed a capital case hearing in the old Supreme Court building just next door. It was my first time attending any court hearing. I was surprised when, just before the sentencing, all of us in the courtroom was ordered to stand. I understood it as a mark of respect before the death penalty was handed down. The entire hearing also showed me how the system upholds the sanctity of life and the important role played by everyone, judges, prosecutors, and defense counsel, before anyone is deprived of his or her life. It was a moment that I remember till today. It is thus not unsurprising that in capital offences cases, there is not only a thorough trial and appellate process where the courts are careful and meticulous in sifting through the evidence and arguments, but there is also a comprehensive support, such as pro bono legal assistance through LASCO. However, recently, there have been many post-appeal applications in capital cases, also known as PACCs, which take up many years and judicial resources. Some of these PACCs were still being filed 7 to 13 years after the first conviction. These PACCs take up not only judicial time and resources, but in actual fact, they have robbed the convicted inmates and, most importantly, their families of what is left in their lifetime, and victims' families of a time for closure and peace. This bill ensures that in respect of PACC applications, there's a balance between due process and rights of PACP, and also preventing the resources of the state from being unduly wasted by frivolous PACC applications. It is against this backdrop that I stand to speak today. Madam Deputy Speaker, I will touch on 3 points in my speech. First, on due process, how the bill can ensure that the accused or PACP can be assured of due process in PACCs. Second, on the liability of solicitors who are representing PACPs. Third, on what we can do together beyond this bill to ensure that more awareness can be raised in relation to our criminal justice system. First, on due process. The new process for a single judge hearing a PACC will save a significant amount of judicial time. This also means that it will be easier for the scheduling of court hearing on an urgent basis. However, a single judge hearing may give the impression that these PACCs are of lesser importance. Since these PACCs are the PACP's last resort, perhaps we should require more safeguards than just one judge presiding over the PACC hearing. This is a point made by Honourable Member Ms. Henny So too earlier. With the use of virtual hearing and technology, it is not difficult to convene a hearing with a quorum of 2 or 3 judges online. Perhaps it can also be clarified that for PACC of a certain degree of complexity, there can be more than one judge. To ensure efficiency, guillotine time or specific time limits for oral submissions and page limits for written submissions can be set prior to PACCs. To borrow from the practice of international arbitration, the courts can also set a memorandum of important issues to be addressed at the hearing so as to focus the judicial time on pertinent issues of relevance and materiality to the outcome of the PACC. Separately, given the time-sensitive nature of the PACC, I hope that there will be assurance that such applications shall be heard urgently and that the AGC and prosecutors will do their best, utmost best to achieve this as well. Next, on the liability of solicitor representing the PACPs. Many defense counsel in these cases are doing it pro bono or on the LASCO scheme. They are playing an important part in our criminal justice system. We owe a debt of gratitude to them and we appreciate their key role and contributions. Inevitably, the role of counsel comes under the spotlight in PACC applications where there tend to be an abuse of process or delay in making such applications. However, not all blame lies on the solicitor. Take, for example, in cases where counsel has already advised the PACP that the chance of success is low, but the PACP insists on making such application. In such a case, I hope that it will be made clear that any cost liability will be borne by the PACP and not counsel, except in egregious abuse of process caused by solicitors. The imposition of personal cost orders against counsel comes under the Criminal Procedure Code, whereby lawyers who file applications that are frivolous or vexatious or otherwise an abuse of the process of the court may have a cost sanctions imposed on them. However, the Court of Appeal in the recent case of Iskandar bin Rahmat has held that a high threshold must be met before adverse cost orders may be imposed. In future, perhaps the Ministry can consider codifying the narrow situations in which cost penalty may be considered against any counsel for clarity. Another scenario is where new solicitors have just taken over conduct of the matter. Some PACPs are known to discharge solicitors and engage new ones at the last moment. In such cases, cost liability should be on the PACP. This is because counsel would be placed in a most difficult position at the cost submissions or hearing because he or she cannot divulge or breach solicitor-client privilege. Where the PACCs are not conducted on a pro bono basis or on LASCO, a suggestion perhaps is to require the PACP to furnish security or undertaking for costs if certain requirements are met. This is nothing new in the civil appellate practice. I hope these suggestions will encourage more defense counsel and pro bono LASCO lawyers who will step forward to contribute. I now turn to raising awareness internationally. Under international law, the death penalty is not prohibited, whether by the International Covenant on Civil and Political Rights, ICCPR, or any other international treaty. In Singapore, capital punishment is only applied to the most serious crimes that cause grave harm to others and to society. In this regard, I also note that the United Nations Human Rights Office of the Commissioner issued a statement in 1984 on the safeguards guaranteeing protection of the rights of those facing the death penalty. In particular, paragraph 6 of the safeguards stated that the steps should be taken to ensure that appeals from a death sentence shall become mandatory, and paragraph 8 stated, quote, capital punishment shall not be carried out pending any appeal or other recourse procedure or other proceeding relating to pardon or commutation of the sentence, end quote. In my view, this PACC bill, which further clarifies the due process beyond the appellate process, is consistent with not only international law standards, but also the safeguards aforesaid. However, we can do more to raise awareness of the approach towards capital offences in our jurisdiction. For foreign PACPs, what are the measures that can be done to engage foreign embassies and governments on our approach towards PACPs who are foreign citizens? On a people-to-people level, what more can be done to raise such awareness? One suggestion, perhaps, would be for our law schools or even the judiciary to host foreign law students on exchange and expose them to the inner workings of our criminal legal justice system. I hope that the foreign students or delegation will, having seen us up close, can better understand Singapore's context and criminal justice system on such capital offences. Notwithstanding the clarifications, Madam Deputy Speaker, I stand in support of the bill. Thank you.